Good evening, everyone. Thank you so much, Lauren. I'm so excited to be here. I'm Soraya. I am a PAC volunteer and an elder law attorney in Rock Hill. So we are going to talk about filing for disability. I will warn you ahead of time, this topic is a little bit dense, and there's a lot of information to cover. So I do encourage you to ask questions, interrupt me if you need to, as we attempt to get through this. All right, I hope you're able to see my screen okay.
Oh, Soraya, I'm going to just jump in for a moment and go over some housekeeping items. Is that okay?
Sure.
Okay, so we are going to have about 40 to 45 minutes of a presentation, and then there will be time for Q&A at the end. You are welcome to type your questions in the chat box, or you can come off of microphone or onto microphone so that you can ask Soraya your questions. And that's about it. And this session is being recorded. So if there are things that you miss or want to rewatch, it will be available on PAC's YouTube channel shortly, like probably by tomorrow morning. So thank you all for joining us, and we hope that you enjoy the session. And Soraya, I'll turn it over to you.
Thanks again, Lauren. I greatly appreciate it. All right, so filing for disability. Of course, before I get started, I do have to make a disclaimer that this information, of course, is just intended to be for educational purposes and give you broad and general information. Should you need legal advice for any reason, please consult an attorney in your state. The majority of benefits that are available to disabled individuals are through the Social Security Administration. Most people are familiar with the program. Most people are familiar with the fact that it provides retirement benefits, but there are two different disability programs that are offered under the Social Security umbrella. They are Social Security Disability, or SSDI, and Supplemental Security Income, or SSI. Both programs require that an individual be disabled, have a disabling condition that prevents them from performing any type of substantial work, but they do have slight differences in entitlement. So when we're talking about SSI, or Supplemental Security Income, we're talking about benefits that are available to individuals that are not just disabled, but individuals who are also 65 years or older and blind. Both require an application, but the limited income and resource requirement for SSI is the biggest difference between the two programs. The medical requirements are virtually the same. SSDI, Social Security Disability Insurance benefits, those are based on on income that individuals have earned and taxes that they've paid into the system. So essentially, a person could only receive SSDI, or Social Security Disability Insurance benefits, if they've worked at some point and paid into the Social Security system. Regardless of their disabling condition, if they've never worked, SSDI would not be an option. So SSI, which we talked about previously, would still be available to them. We talked briefly about SSI being for those who are 65 and older, blind or disabled, and SSDI requiring work activity. But it's not just one's own personal work that would make them qualify for SSDI. A person's eligibility could come from a parent or a spouse, essentially credit through a family member. there are two basic requirements in addition to being disabled for SSI benefits or supplemental security income. They are one's income and resources. What that means is, even if a person is disabled, if they have not worked long enough to qualify for SSDI, and SSI is the only option available to them, if they have income or resources that exceed the limit, they may not be eligible for SSI. Resources can include things like homes, bank accounts, cash, stocks, bonds. Generally, people think that you have to have a mansion or a fancy car or something along those lines in order for it to be over the resource limit, but it's actually quite small. For SSI entitlement, a person only has $2,000 in resource limits. So that includes all of the things that you could own in this list. Real estate, of course, could take you out immediately, but it generally does not include property that a person lives in. So if someone has land, and of course we're in the South, people are land rich. If someone has a piece of parcel, even if it's not worth anything to them or they can't really do much with it, but it's worth a few $1,000s, but they have nothing in the bank, no cash, no stocks or bonds, that alone could make them ineligible for SSI, even if they are in fact disabled. SSDI is a little bit different in that one's resources or income doesn't really factor into eligibility. They're only looking at whether or not a person is in fact disabled and paid into the system, but paid into the system recently enough. So they do have a work test where you are required essentially to have worked for at least 5 of the last 10 years and have enough work credits to be what they considered insured. So a lot of people are disabled for a long period of time, and maybe they decide not to pull the trigger on filing for benefits for a number of years. Let's say you became disabled in the early 2000s and you stayed at home and took care of children or took care of elderly loved ones, and then decided to file for benefits 5 or 6 years later. Even though you worked hard and paid into the system in the past, if it's not recent enough, you may still not have enough insured status for SSDI. It doesn't mean that the money you've paid into the system is lost. It simply means that for this particular program, there's no entitlement. But those, those funds could be used, of course, for retirement benefits down the road. We talked about income and resource limits, and I mentioned briefly the $2,000 limit for an individual. If we are talking about a disabled couple, they're allowed to have slightly more, but not much. They're not, unfortunately, allowed to double. They could have about $3,000 in resources. The income piece of this is a little bit more complicated. There are both rules that prevent an individual from being entitled to benefits because they've worked substantially, called SGA, and other rules that prevents an individual from being payable because they're over the income limit. So SGA, or substantial gainful activity, is a number that SSA assigns every year. So that limit changes from year to year. Right now, it's around $1,300. In 2022, it'll be slightly over $1,300. If a person is disabled, but they're able to work and earn at least that much or more, and that's not what they're bringing home, but their gross income, then they are technically working at a substantial level. And working at a substantial level means you cannot be eligible for Social Security disability or SSI. As it relates to SSI, however, you don't even necessarily have to be at SGA. You don't even have to be at the maximum limit. You just have to make enough to kick you out of the bracket, for lack of a better word. SSI is going to look at income that comes in from employers, but there are also other things that could be considered income, such as a person living with another person and they're getting support. That support could be considered a type of income that could essentially make them ineligible. There's not really a number or an amount that I could share as far as SSI is concerned that would make one ineligible or eligible for the program. It really just depends on their living arrangements and a number of other factors, but income earned and income in the form of support could count against a person for SSI purposes, which is not the case for SSDI. We talked about insured status briefly. I'm kind of jumping all over the place here, but insured status for SSDI is what I mentioned earlier, where the money that you pay into the system has to come in recently enough. You have to have enough work credits for at least 5 of the last 10 years to be considered insured. So if a person is consistently working, they become ill, they have to file for benefits. That happens within, let's say, a year or a few months of the event, then they can still have insured status and be eligible for SSDI. But as I mentioned previously, if it's too far in the past, even if there's substantial work there, it's not going to matter. I'm not going to read the slides to you, which is essentially what I've mentioned. There is a number that's assigned to each credit that Social Security will consider. So even if a person is working, if they're making too little money, they still may not have accrued enough credits. $1,470 is the number in 2021 for a person to earn 1 credit, or $58.80 for the year. So if a person earns at least $5,880 in the course of 1 year, they can earn the 4 credits necessary, which is the maximum that they can earn anyway. They can earn the 4 credits necessary to maintain their insured status. So even in the case of a disabled person, if they're working part-time, they may still be able to meet this threshold and maintain their insured status until they reach a point where they can no longer work. The benefits, again, are based on disability, but SSI, another key difference is that you are generally eligible for those benefits a little bit earlier. With SSDI, or Social Security disability, as most people call it, there is a waiting period. What that means is if you are determined, or if you say, I became disabled on December 1st, 2021, you have to be disabled for 5 consecutive months before you are finally eligible for benefits, which sometimes is a disservice to a disabled individual, especially if they have a terminal illness, but that is a requirement of SSDI. The reason why SSI is attractive to a lot of people is because a person is eligible for those benefits the month that they apply. So if a person says they are disabled in December, they also file in December, their eligibility will begin a lot sooner because they won't have that 5-month waiting period. But for SSI entitlement to kick in again, you have to have, or meet rather, the income and resource limits requirements, which a lot of people are not able to meet because they're so low. We talked about the fact that individuals need to have work credit to be eligible for benefits under Social Security disability programs, but there are benefits available for children with disabilities. SSI, of course, is one of those programs. Anyone who is a child or over 65 and disabled could be eligible for this program. There's no work requirement. As long as the disability is met, the income and resource limits are met, SSA will consider that person to be disabled and eligible for SSI. In the case of a child, however, they will look at the household income, the resources of the parents. So we may have a severely disabled child, unfortunately, but if the parents have the means to support them based on Social Security's rules, they may be found to be medically disabled, but not be payable because their parents have resources or income that exceeds the limit. In some cases, they may not even get a medical determination because SSA will attempt to deny them on a technicality just based on the excess income and resources. So this can be a very tricky area for children, especially because they're not just looking at the child's resources, but both parents' resources as well. Even things like child support could be attributed as income to the child and a number of other factors that could make them not payable. There are, however, benefits available to disabled children under Social Security disability, even if they did not work, and those are called Disabled Adult Child Benefits or DAC benefits. Any child who was found or deemed to be disabled before the age of 22 could potentially be eligible for benefits from a parent's record. Only issue, though, is that the parent does have to be eligible for benefits. So if the parent is not retirement age or they're not disabled themselves and drawing from their own record, then the eligibility doesn't exist. But this does allow a child who has never worked to tap into slightly higher benefits than they would be eligible for under SSI, or to be able to receive Medicare entitlement or just cash benefits that doesn't restrict them to income and resource limits like the SSI program. Disabled widows benefits. In some cases, we have people who their work was in the home and they never paid into the system. And they may not be eligible for benefits under their own record, but they may be eligible for benefits under a spouse's record. In order for this to happen, however, they cannot be a younger widow. They do have to be at least age 50, and they have to have had the disability before their spouse's death, or the disability has to start within 7 years of the spouse's death. If that happens, and they do not have eligibility on their own record to receive benefits, this would be a good option. And again, would not have the same restrictions as SSI, would still fall under those general guidelines that requires a person to be disabled, but doesn't really look at their income or resources. I hear this all the time. Everyone says, oh, I hear you have to, I hear you have to apply for Social Security a few times before you're actually approved. And people don't realize that that actually is not true at all. There are certain cases that are automatically approved. My background is that I actually worked for SSA for 10 years before becoming an attorney. So I've actually seen cases that were approved in as little as 2 days. So it does happen, but they do have to meet certain criteria. Individuals who have terminal illnesses, if they have, let's say, stage 4 cancer or ALS or some other illness that SSA automatically determines to be a terminal illness, they will get a quicker disability decision. And in most cases, if you contact Social Security to apply for benefits and you tell them, I have cancer stage 4, they will classify this as a quote Terry case, which will get you fast tracked to the front of the line to get a faster appointment and get the ball rolling. There are other conditions that receive compassionate allowances, which is slightly different from a Terry case. A Terry case still has to go through the normal process, still has to go through evaluation. They'll still review medical records and do some of those same basic things. It just happens faster. With the compassionate allowances, however, once they've confirmed certain disabilities or disorders, those allowances happen very, very quickly, even quicker sometimes than the Terry cases. So those are two areas where individuals get approvals, certainly much quicker than multiple applications, but in days in some cases. Veterans, of course, are eligible for benefits through the VA, but having veteran disability can help with Social Security disability entitlement. If an individual has 100% rating through the VA, in most cases, they're also able to get fast-tracked and get a faster decision. The Social Security Administration and the VA work very well together, and they're able to transmit records quickly, so those decisions take no time at all. Same requirements are in place. They still have to have a physical or mental condition that prevents them from working, from performing at a substantial level, and that condition is expected to be terminal or last 12 months or longer. If they meet those criteria and they have 100% rating, then Social Security disability would be an easier thing to achieve. We talked about SGA, or substantial gainful activity, and how it could impact entitlement. In 2022, that number is going to be at about $1,350, so roughly $1,300 a month. That is gross. A lot of people think that this is what they bring home, but it is not. So in order for someone to be eligible for benefits, they have to be working at a level that is below SGA. So even if you're telling me, or telling SSA rather, that you're working 5 hours a month when you used to work, of course, 40 hours a week, if you're earning more than what's considered SGA, that could still make you ineligible for benefits. It's not necessarily the type of work, how physically intensive it is, how long it takes you to do it. If the numbers don't line up, that could impact eligibility. There are programs that individuals can participate in, such as voc rehab. Most states have this available to them, and this does sometimes help with Social Security disability entitlement. Not in the sense that it makes it faster, but in that if a person is working, there may be certain things that could be written off, or certain exemptions that could apply to them that would allow them to work and still pursue Social Security entitlement. We talked about how a lot of people believe that you have to apply a number of times before you're eligible. So of course, if you are denied for benefits, there are always appeal rights. 9 times out of 10, there are appeal rights. So if an individual is denied, usually they have 60 days to appeal that decision. Sometimes SSA sends out the notices and they don't get to you, and you may not get them. So it is 60 days after you receive that notice. Some people fail to appeal because they think they've missed the deadline. But if an appeal is necessary, you could always submit a statement of good cause to SSA, explaining to them why you weren't able to submit that appeal within the 60-day timeline. If it is a reasonable cause, they are very lenient in accepting them. There are 4 different levels of appeal. The reconsideration level, which is the very first level of appeal that comes right after your initial denial. If a person is denied at the reconsideration level, then they go to the hearing level, which is usually the longest period to go through. And if it is denied at the hearing level, then an individual could request a review by the appeals council. The appeals council at this point is just looking at what took place at the hearing, making sure that nothing was done improperly. And if something was done improperly or something needs to be reviewed, they will kick it back to the hearing level to be reviewed again. But if there was nothing done wrong, or if the decision was proper, it would also be denied at the appeals council level. If a person still believes that they have a case, they would then have to bring it before the federal court. This is outside of the SSA system, so everything has to be done privately And if you're awarded at this level, then it is sent back again to SSA for review and more work. Most people usually stop at the third level. Usually by the time you are denied by the appeals council, it isn't necessarily worth it to go to the federal level, but there are cases where it is. Statutory blindness, that is a category that SSA assigns to disabled individuals, which essentially gives them a bit of a boost in terms of their earning requirement. So if an individual is disabled and they are considered to be stat blind, then they have a slightly higher SGA limit, meaning they could make a little bit more money and still qualify for benefits. So although I talked about that $1,300 for SGA, if a person has statutory blindness and they're earning a little bit more than that, it may still be worth it to reach out to Social Security or a professional to pursue a disability claim. Statutory blindness, of course, requires insured status, just like regular Social Security disability, other regular disabilities under the Social Security disability umbrella. As long as an individual has the minimum requirements, they could be considered for stat blind. All right, so essentially with all of these programs, it really is about planning and knowing what's out there and what's available to someone. There are programs available under one's individual record. There are government-specific programs that have income and resource limits. There are programs that are available to disabled children, as well as programs available to widows. All of those have slightly different rules to them, but they all require evidence. So if there's anything that I can leave you with, is that if you're considering applying for disability, make sure you are actually gathering your evidence. A lot of people are disabled, but they don't go to the doctor. They don't follow regular regimen because they already know what's wrong and they know what works. But with these programs, they're not going to rely on your word. They need hardcore evidence from medical professionals confirming that this condition is in fact disabling and that the condition prevents you from doing any type of work. A big thing that a lot of people miss out on is that they feel like, well, I used to be an accountant. I can't do accounting work anymore. I'm disabled. But that's not necessarily so under the Social Security program. If you have other transferable skills, and perhaps you're not able to interact with people at the same level, but you could still do some type of work, that still may not, you still may not be considered to be a disabled person. So the rules are not as straightforward as most would think. There are multiple components to it, but in addition to looking at your disabling condition, income and resources for SSI, they're also looking at your past work history and your education, the biggest piece that most people don't think about. If you have an advanced degree, for example, you could probably do other work, but someone who has only reached the high school or middle school level and maybe doesn't speak English, they may be able to qualify for disability. I don't want to say easier, but they may meet the requirements faster than you would because they have no other options. So as you think about applying for disability, think about all of these different factors, and plan accordingly. All right, so I will now open it up to questions. I didn't want to overwhelm you with too much information. I covered a lot, but opening it up to questions to whoever has it. I think someone raised a hand. Let's see. All right, John, feel free to share your question.
Sorry, I was having trouble getting unmuted there. How is it? Oh, that was an excellent presentation too. Thank you very much, Soraya.
Sure thing.
Okay, a lot of information to be covered, I can tell. Very, very technical, but appreciate it. Didn't know there were so many things. As far as a determination made on the amount of that a person's awarded for disability, I know that there was a time variable there and amounts, and I saw something about credits, per year being like, you gave us a number of 5,880 or something like that. But how much can a person expect, or should they, how do you calculate ahead of time what you'd be eligible to gain from disability, your payment?
Sure, that's a great question. So of course, the Social Security statements that you receive, which they used to send them out every year, but they stopped, those statements would be a good indication as to what you can receive. When you look at what your benefits would be at full retirement age, that is typically the amount that a person would be eligible for disability. And then there's usually a family maximum that's payable. So there may be additional benefits payable to spouse and children, but the amount due to someone at full retirement age is typically the amount they'd receive if they become disabled. And it is based on average of their income.
Okay, thank you. Can I just quick follow up to that? Does that amount vary per state, or is that given like cost of living inflation? Like, is it different for South Carolina versus California?
When we're talking about Social Security disability income, it does not. It's a flat rate. When we're talking about SSI, however, there are other states that have supplements. So New York, California are actually two states that have state supplements for SSI, but that does not apply to Social Security disability.
Thank you.
You're welcome.
Soraya, I have another question that was given to us in advance before the presentation, and that is, how does retirement work if one files for disability? I'm sorry if you've covered this, but that was one of the questions we had.
I did not. So if a person, of course, becomes disabled first and they file for disability benefits, they just continue to get disability. They're already receiving the amount that they would have received at full retirement. So they will at no point need to apply for retirement. At some point, usually after 65, the coding in SSA system will change over from disability to retirement, and they'll continue to get the same amount. If on the flip side, however, they've retired early and they start receiving early retirement benefits, which those benefits are reduced, and they become disabled or later apply for disability benefits, then their disability benefits could also be reduced, because SSA would essentially claim credit for however many months they receive early retirement before they became eligible for disability. So on one end, the benefits could remain the same. On the other end, it could mean that the benefit is less if you retire before you apply for disability.
Okay, thank you so much.
You're welcome. All right. I think that might be it.
It looks like John, did you have another question, John?
I do have another follow-up, please.
Oh yeah, please go ahead.
You talked about getting, someone to help you with this. Like, how does third party help work, like yourself or others? Does a third party get paid? What scenarios do they go through? How do they represent you from start to finish? That type of thing.
Sure, that's a good question. So usually with Social Security disability, a third party isn't paid unless you're approved. It's paid on a contingency basis. So if you apply for Social Security disability and you have retroactive benefits, then that person would collect a portion of your past due benefits for their fees. Social Security does cap that at 25%, not to exceed $6,000. But the person could petition SSA for additional fees if they determine that representing you was a little bit harder, I guess, or required the higher fees. As far as how they represent you, of course, they would assist with gathering evidence. Social Security would not be contacting you directly. They'd be contacting your representative. They'd be reviewing the medical evidence, in some cases, preparing briefs for the Disability Determination Center or the hearing office to just kind of outline your case and explain why it should be approved. That's pretty much it in terms of representation. If we're talking about someone who has a Terry case, or one of those compassionate allowances, I would usually tell people it's not even necessary to get a third party's assistance because it's almost a shoo-in. And most attorneys that I'm familiar with will start representation after a person's been denied, but there are some who will start from the beginning, including taking your application, and you provide all the information directly to them and they serve as your medium basically, or your intermediary between SSA. So that's pretty much it.
Excellent. Thank you very much
You're welcome.
for your answer. As a follow-up, Soraya, again, might as
Go
well
ahead, John.
get our money's worth, right?
Yeah, you might as well.
The when it comes to where that person represents you is from, does it matter what state, if they're out of state or someplace else, or is it better if they're from the state where you're currently residing, or do they have to have a license there, or how does that work? Anything?
It does not matter because Social Security is federal. So essentially someone from any state could represent you. When you do get to the point, however, if you have to go to the federal level, then you would need someone who is licensed in that state to take it to the federal level. But prior to that, anyone anywhere could represent you.
Okay, very good. Thank you so much again.
You're welcome. Thank you for your questions. They were great. All right. Anyone else or any other questions that you were given prior to, Lauren?
You said you couldn't.
No, I don't have any
Yeah,
additional
I feel it.
questions. If there aren't any additional questions from the audience, I just wanted to let everyone know, of course, thank you so much for attending. And we are going to, I'm sorry, I had to do a mute. Thank you everybody for attending. And we're going to make this session available on PAC's YouTube channel. So you can visit there. And I also shared Soraya's company's name and website on the chat, but I do see a raised hand. So I will, I think this is Arlene. Go ahead, you can ask your question.
I've got multiple disabilities. Do they look at all the disabilities as a whole, or they see which one's more severe than the other?
They do look at all the disabilities as a whole. The name of the game really is what keeps you from working, what keeps you from performing substantial gainful activity. So in some cases, people may think, well, I have cancer and that's the most pressing thing, but you may also have back problems or asthma that keeps you from working in a factory, and high blood pressure or whatever. And all of those things together are considered to determine what type of work you can perform if they decide that you can perform some type of work.
Okay. So I'm already talking to a disability lawyer in my town, and I have already filed for Social Security. I'll be 62 next week. And she said, we'll go ahead and do that. And that way have a little bit of income coming in. And she would go ahead. My last day of work is January 21st. And that day she's supposed to go ahead and file for disability for me. Is that the correct way to go? I mean, am I doing everything all right there?
It sounds like you are. In your case, I mean, earlier I mentioned how when you file for early retirement and then you become eligible for disability, how it could reduce your benefits. It sounds like what you're describing is that your disability began way before 62. So
Yeah.
if you were approved, they'd be retroactive. So even if you do start receiving a little bit of money from early retirement, it just means your back pay won't be as large, but it's not going to affect what the end result would have been. So sounds like you're on the right track.
Okay, all right. Thank you.
You're welcome. I think, John, you had another question?
Yes, it's me again.
Hi, John.
Your ability to earn income, that gentleman sparked that thought. Your ability to earn income both after you're approved for disability and before. So during the waiting period, for instance, that 5 months for SSDI, are you able to earn any income at all, or is that limited to like $1,300 per month, or no income, no work or anything?
Unfortunately, you're limited to the SGA limit, whatever that is, both when you apply and during the waiting period. So if you're able to work and you're earning less than what's considered substantial, let's say you're grossing less than 1,300, then you would be perfectly fine.
That 1,300 is monthly, right?
It is.
Okay.
But it is gross. Another thing that's important to remember is that SSA will give you credit for certain things. So if you're a disabled person and you have to take a lot of medication, for example, and you're paying $200-300 a month out of pocket for meds, and you require those meds in order to work, they'll deduct that from what they count. So even if we're talking about this $1,300 limit, it could potentially be a little bit more depending on the situation.
And is that medication the cost to you, or is that the cost of the medicine itself, really? I mean, is
The
it like
cost
the
to
insured
you,
cost? Okay,
your
that's your insured
out-of-pocket
cost.
costs.
Your out-of-pocket cost. So,
Yeah.
so you really don't get credit for it if you're paying $500 a month for insurance, for medical insurance, which gives you your pharmacy. You don't get credit for that. You really only get credit for the $20 copay that you're paying for the medicine.
You can get credit for that if you're paying that $500 out of, but that's not something that is on SSA's radar. So it's something that you would have to request. The medication, of course, is something that automatically shows up on their forms. If you're paying $500 out of pocket a month for insurance, and that insurance is what you require for your disabling condition, that could be something that's excluded as well. But you have to provide proof of that, and you have to request it. It won't be provided automatically.
In your time, and I don't want to guess get too nosy, but when you're working with people with Parkinson's, which is our case, here for the most part, I guess, what do you find to be the biggest obstacle for people to cross, or period, maybe the same for all groups, but for Parkinson's in particular? Because I know a lot of people, they're articulate, they seem well, like myself at times, but it falls apart fairly quickly other times, And so that facade, like I say, you can't always see where the pain or hurt's coming from or where it is, where it's building.
I think the biggest issue that I've come across with most people is that they don't want to actually, you talk about how it falls apart. They don't want to actually, I don't want to say embellish, but they don't want to actually explain in great detail how much and how often it falls apart. And that's important. So you may be articulate and able to do something for a brief period of time, but if it's falling apart several hours throughout the day, and you're having to take multiple breaks, or you require so much support, then that's something they should be aware of. So in most cases, people aren't really detailing their struggles enough. So what's on the surface is all they're going to see. And also with the doctors, they're focusing on the positive, which is a good thing, and their improvements, but they're not discussing enough what their struggles are. And those are going to be essential in getting benefits.
So you have to be brutally honest and take the bad. Okay, got it.
Be brutally honest. Yeah. If you wake up and after 5 minutes, you're already out of breath and you can't do anything, or you're able to think clearly for 20 minutes, but then you're completely foggy and you wouldn't realistically be able to do a job, or an employer wouldn't be able to rely on you, that's something they need to know. That matters.
And that's hard. Yeah, I got it. Okay. So it's kind of like, instead of fighting to keep a job or get a job, you're fighting to stay out of work. That's different.
It's yeah, and it's something that doesn't sit well with a lot of people.
Yeah.
You know, I've had people say, hey, I've been disabled for quite some time, but I actually decided to stop working because I had children and I decided to stay at home with my children. And it's like, well, that's nice. But you are in fact disabled. And if we're focusing on the fact that you stop working because you're staying home with your children, that's not going to help you get disability. We
Right.
have to outline why you are unable to perform any type of substantial activity because of this condition. And also why an employer wouldn't realistically be able to keep you on if you need to take a break every 20 minutes.
Mm. Good, thank you.
Sure, you're welcome.
Dramatic about everything that else.
Are you going to send out the slides for this? I meant to ask that.
I think Lauren, I might have made some edits to it. So I will send the edited slides to Lauren and you're free to share them. But I know,
Okay,
of course, the
perfect. I'll
video
do
will
that.
have that information as well.
So I'll
Great.
send out the slides and the YouTube link. If anybody wants to rewatch the video or any parts of it, I'll send that out as well.
I have one more question.
Sure.
When would I be eligible for Medicare?
That's the sad part. So Medicare does have a 2-year waiting period, and it's 2 years from when you are entitled. So that 5-month waiting period included. So if you are entitled to benefits in June of 2021, then you're not eligible for Medicare until June of 2023, unless you have ALS or kidney disease, kidney failure.
About emergencies.
Okay. Well, they don't have any kind of emergency insurance that you can apply for, because once I leave work, I'll lose my insurance. I'll have to go out and buy some insurance.
Yeah, Medicaid is going to be your only option at that point, but of course, Medicaid is a needs-based program, so you'll have to meet their other requirements for that. One of the other good things about SSI is that if you do meet the requirements for SSI, that does give you automatic entitlement to Medicaid. That's
I
going to
don't
be your
qualify.
only insurance option.
Yeah, I don't qualify for SSI, so. But suppose I don't say that. I can't go
It's
out
one
and
of
buy
the
my.
rules that I personally think should change. I mean, if a person is determined to be disabled and they have stage 4 cancer, it doesn't make sense that they would have to wait 2 years for Medicare.
Yeah,
But
I take a lot of
unfortunately,
medication. So I take a lot of medication, and the cheapest one I found had a $300 deductible for prescriptions. Some of them are $1,000 deductible, means that they don't pay until you reach your deductible.
yeah.
So I guess just keep looking. You got any suggestions where to look for the Affordable Cares Act, the health?
Affordable Cares Act is going to be your only option. And of course, with pre-existing conditions, your options are going to be limited regardless.
Okay. All right.
Sure, thank you.
Thank you.
All right, you're welcome.
Well, if no one has any additional questions, we can close out this session. And thank you so much, Soraya, for hosting another informative session. Just for anyone who missed Soraya's last session, she did another excellent presentation on estate planning for individuals living with chronic conditions. And that will also be available on our YouTube channel. So thank you all for attending. I hope that you enjoyed and learned quite a bit from this session. And thank you, Soraya, for your time tonight.
Thank you all.